Welcome back to Law Call. Ted Howell, Perry and Young here again, and I think we now have a phone call. Cynthia, you're on the air. Please proceed with your question.
Hi, good evening. I want to know, with heir property, my uncle passed, however, he didn't have a will. So is his wife entitled to that property, or is she entitled to his piece of the property, or do it just remain with the other heirs?
Okay, very good question, Cynthia. This situation with the uncle has now passed away without a will, so it's living in that intestate world that you discussed. And so if you would, John, just kind of explain how that would go in that particular situation.
So we touched on this in the opening there, and there's the two ways it goes. Without a will, it's called intestate. That's the legal term, means you don't have a will. And it would still need to go through the court process, but I think to not cut through the chase too easy or too quickly with this, when you're passing away without a will, there are statutory guidelines, and basically the wife is the one that will inherit most of the assets. If there was a will, or if there was a claim some other way, and it sounds like maybe some of the other folks were using the property maybe, there's potential for some claims out of there just through use or things like that, but you're going to run into that, and that's going to be one of those that you get into court and you kind of have to wrangle with the court system to figure out if there's any way that someone who's not the first step, it's kind of the first step would be the wife. If she's not around, then it's his children. And then if it's not there, then it goes back up to his brothers and sisters. And if none of them are around, then it would go down to their children. So if it's your uncle, it sounds like you might be kind of far back in the line, but that's not to say that you may not have a claim there. It's just that's generally the way it goes. That's kind of the cut through the chase.
Right, and one thing interesting I think that Cynthia maybe alluded to is that there may be other people that have an interest in this property. And what can happen if you have multiple parties that own a piece of real estate together that cannot be divided, and if for some reason all of these individuals cannot get along, there is a way, a legal process that's called partition, where you can essentially force a legal sale similar to a foreclosure. And at that point in time, it will go to the courthouse steps and it will be sold, and the property would be divided by percentage to the respective heirs. So there is an avenue if there's some reason that you do not want to be in that same legal ownership of that property with this particular individual. But as John said, unfortunately, without a will, it's going to go through the intestate laws, which will likely be the wife, potentially other kids, but very unlikely that it would reach you under these circumstances. So it's a difficult situation anytime you're dealing with family, and that's why it's very, very important that you plan ahead, especially when you have a piece of property that's owned in common with other people. You want to make sure whatever your wishes are laid out in advance so that it doesn't lead to, I mean, look, there's no way to stop people from fighting 100%. But you can, you know, a good plan can help alleviate some of those concerns afterwards.
Yeah.
And John, what do you typically, you know, I've had this question before as well, like, do you advise people to let their heirs know what they're going to expect to see? Or do you, I mean, obviously that's their personal decision, but it can be a surprise to someone if they find out they've been disinherited. I mean,
it definitely is, and a lot of times what we've seen is that that when you get the disinheriting side of things, there's been a rift in the family, and most everybody knows about it, so it's not surprising in that sense. Still is a surprise, I think, maybe to the person it happens to in the long run. It doesn't settle any animosity that was there, that's for sure. So we try to dissuade people from doing it. Let's reach out and try and do something, at least give them a little bit. Maybe bury those hatchets, as it were. But as far as the other assets go, I think it is a good idea to let people know this is how I'd like things to go, because even if, and Cynthia's call was, I don't have a will, but Uncle always said that he wanted this to go this way and this to go that way. At least it gives you an idea. And if you're going to court, it may not hold up, it may not get you very far, but at least you got something to put up there instead of we're coming there begging for a piece of the pie when you don't have any leg to stand on.
Yeah.
Another one that is kind of tricky, which you definitely have to tell somebody, is who your personal representative is going to be. That would be your, what we used to call a testator, or testatrix if it's a female,
Right.
or testator. That's the person that's going to administer and be legally responsible for your estate. Now, you can go hire a lawyer to do that after, but it's usually you appoint a family member because they know where everything is, where the codes are to the safe, and that sort of thing, keys to the locks, all that. But you need to tell them ahead of time before, when you pass away, surprise, surprise, you're in charge.
Right.
So that's never a fun one. So we definitely make sure that. And there's some of our forms actually have them agree this, I'm going to be the
Right,
person
it's a good
representing.
idea, so they know
Yeah.
what they're getting into.
Yeah.